They really thought they could just muscle this through. They thought that if they just slapped a pilot program sticker on a massive structural overhaul of how safety net hospitals buy life-saving medicine, the courts would just look the other way because it's the administration and, well, they're used to getting their way. But the First Circuit Court of Appeals just looked them right in the eye and said, no, not today, not ever if this is all the homework you've done. We're talking about the 340B rebate model, this hyper-specific, deeply technical mechanism that basically keeps rural hospitals and community clinics from going under. And the administration tried to flip the script. They wanted to move from discounted prices to a pay up front and we'll maybe pay you back later rebate system. And look, if that sounds like a bureaucratic nightmare designed to choke the cash flow of the very institutions serving the most vulnerable people in this country, it's because it is. But they didn't just try to change the policy. They tried to do it with a record so threadbare, that is the court's word, not mine, that it basically insulted the judge's intelligence. The First Circuit just denied their emergency request to stay the injunction. It's a complete freeze, a total halt. And the reason this is a nightmare for them isn't just about this one drug program. It's because the court just handed every legal challenger in the country a roadmap on how to dismantle their entire healthcare agenda. They signaled that the policy is procedurally vulnerable. In legal speak, that means they were lazy, they were arrogant, they skipped the steps, and now the whole thing is just frozen, just like that. You can't just run a multi-billion-dollar healthcare system on vibes and executive fiat. And the fact that they're acting surprised that a court demanded actual evidence, actual data, and actual administrative record, that tells you everything you need to know about where their head is at. They didn't just lose a case, they got caught trying to cut corners on the lives of people who can't afford for them to be wrong. And the court finally had enough.
All right, let's get into the bones of this. To understand why the First Circuit just gutted this pilot program, you have to look at the sheer technical arrogance of the rollout. We aren't just talking about a minor administrative tweak here. We're talking about a fundamental 30-year reversal of the 340B drug pricing program. Since 1992, the rule of law was simple. Safety net hospitals get an upfront discount. They buy the drugs at the ceiling price, they save the money immediately, and they plow those savings back into prenatal care, rural clinics, and emergency rooms for people who don't have a dime. But the administration decided to test drive a rebate model, and they didn't just suggest it, they made it mandatory for the first 10 drugs subject to the Medicare price negotiations. We're talking heavy hitters like Eliquis, Xarelto, and Januvia. The mechanism was surgical in its cruelty. Under this pilot, hospitals would be forced to pay the full wholesale acquisition cost, the sticker price, at the pharmacy counter. Then, and only then, would they have to submit a data report within 45 days of dispensing the drug to a private third-party platform called Beacon. The drug companies then had 10 days to review and pay the rebate. If that sounds like a massive interest-free loan from cash-strapped hospitals to multi-billion-dollar pharma giants, well, that's exactly what Judge Lance Walker saw. He used a word that should be a career ender for any policy director: anemic. He called the administrative record anemic and threadbare. Think about that. The Department of Health and Human Services, HHS, and HRSA tried to overhaul a 30-year-old pillar of the American healthcare safety net with a record that, in the court's view, barely qualified as an explanation. They ignored over 1,100 public comments from stakeholders who were screaming that this would cost hospitals over $400 million just in compliance and IT overhauls. The forensic reality is that the government tried to bypass the Administrative Procedure Act. They tried to argue this was just a procedural change, but you can't call something procedural when it threatens the actual liquidity of a rural hospital in Maine or a clinic in North Dakota. These institutions don't have the float to pay full price for Eliquis and wait 2 months for a rebate that a drug company, acting as both judge and jury on the Beacon platform, might decide to deny because of a duplicate discount technicality. And that's the mischief the AHA pointed out in the complaint. The administration essentially wanted to hand the keys of the vault to the drug companies. They wanted pharma to manage the IT, verify the claims, and decide when the hospitals got their money back. The court saw the likely violation of the arbitrary and capricious standard because HRSA failed to even consider the reliance interests of these hospitals. You can't just wake up after 3 decades and say, actually, give the money to the drug companies first and we'll figure out the math later. The First Circuit's refusal to stay the injunction is the final nail because it confirms that the administration's legal defense was just as threadbare as their policy record. They couldn't show irreparable harm to the government if the program was delayed, but the hospitals could show it in spades: potential service cutbacks, staffing freezes, and a literal sea change in how they manage their most critical accounts. It's forensic proof that the move fast and break things mentality doesn't work when you're breaking the Administrative Procedure Act and you're doing it at the expense of hospitals that are already hanging on by a thread. They thought they could use the Inflation Reduction Act as a shield to smuggle in a pro-pharma rebate model, but the court just peeled that shield away. The receipts show a rushed, opaque process that skipped the rules of the road, and now the entire pilot is a lead weight around the administration's neck.
But see, this is where we have to stop looking at this as a clumsy mistake or just another legal oopsie from a rushed administration and start looking at the architecture of what's actually happening here. Because if you think this was just about one drug rebate program and one circuit court, you're missing the forest for the trees. This is a feature. It is a decade-long, maybe even a half-century-long strategy to essentially gut the administrative state from the inside out, and then hand the keys to the very corporations the government is supposed to be regulating. When the court calls their record threadbare or anemic, they aren't just insulting the lawyers, they are highlighting a pattern of intentional negligence. Think about it. If you're an administration that fundamentally doesn't believe the government should have the power to tell Big Pharma what to do, how do you dismantle a 30-year-old safety net like the 340B program? You don't just delete it, that would be too loud. No, you make it unworkable. You introduce so much friction, so much procedural chaos that the system eventually just collapses under its own weight. This is the classic starve the beast playbook, but it's been updated for the 2020s. It's not about cutting the budget anymore, it's about regulatory sabotage. You take a functioning discount model, one that actually helps people who can't afford to live, and you replace it with a pay now and pray rebate system managed by a private entity like Beacon. You are effectively outsourcing the government's police power to a private vendor that answers to pharma. That isn't an accident. That is a deliberate shift of power. It's a move toward a world where the administrative state isn't a group of experts making data-driven decisions, but a skeleton crew of political appointees rubber stamping whatever the industry lobbyists put on their desks. And we've seen this movie. We've seen it with the attempts to privatize the VA. We've seen it with the systematic underfunding of the IRS. And now we're seeing it with the literal infrastructure of our healthcare safety net. They want to prove that government doesn't work, and the easiest way to do that is to be the ones in charge of making sure it fails. They send these policies to the courts with these anemic records because they're betting on a judiciary that's been packed over the last 10 or 15 years with judges who they hope will be ideologically aligned with the idea of a weak executive branch. Except they got it wrong this time. They ran into a court that actually still cares about the Administrative Procedure Act. But don't think for a second they're going to stop. This is part of a broader 50-year project, the same project that gave us the end of Chevron deference, the same project that's trying to move us toward a unitary executive, where the president can just fiat major economic changes without a single page of supporting evidence. They are testing the fences. Like the raptors in Jurassic Park, they are jumping at the electric fence at different points just to see where the power is out. They tried it with the rebate model in Maine and Boston. They're trying it with Medicare negotiations and other circuits. They are looking for the weak point in the rule of law. And the nightmare for them isn't just that they lost this specific program, it's that the court just reminded the world that executive power isn't a magic wand.
You actually have to do the work. You have to follow the steps. You have to respect the reliance interests of the hospitals and the patients who would be destroyed if you just decided to flip a switch on a Tuesday because a lobbyist told you it would increase efficiency. Efficiency for whom? That's the question they never want you to ask. It's efficient for the drug companies to keep the hospital's cash for 60 days. It's efficient for the government to stop having to oversee the discounts themselves. But for the person in a rural clinic waiting for a heart medication, it's a death sentence by 1,000 paper cuts. This pattern of behavior, this move fast and break things approach to governance, is designed to create a sense of inevitability. They want us to feel like the system is so broken, so complex, and so anemic that we should just give up and let the private sector run the whole show. They want to turn the Department of Health and Human Services into a referral service for private corporations. And every time a court like the First Circuit stands up and says, "You can't do this," it's a momentary break in that momentum. But make no mistake, they will be back tomorrow with a different pilot program, a different technical tweak, and a different way to try and strip the public of its power. This isn't a one-off. It's a siege, and the siege doesn't end just because one battering ram got stuck in the mud. So where does this leave us? Because if you think the First Circuit just saved the day and we can all go home, you haven't been paying attention to the end game. The stakes here aren't just about a pilot program for 10 drugs. They are about the survival of the American medical safety net as we know it. If this program had been allowed to move forward, if the court had looked the other way at that anemic record, we would be looking at the immediate, systemic decapitation of rural and low-income healthcare. Let's be brutally honest about the math. We are talking about hospitals that operate on 1 or 2% margins on a good day. When you force those institutions to float hundreds of millions of dollars to pharma, essentially acting as a high-interest credit line for companies that are already making record profits, you aren't just testing a model, you are triggering a liquidity crisis. If this stands, if the administration eventually finds a friendlier court or successfully appeals this to a Supreme Court that has shown a, let's call it a peculiar appetite for dismantling administrative power, the tomorrow we're looking at is one where your local community clinic simply disappears, not because the doctors don't care, not because the patients aren't there, but because the math was rigged by a procedural tweak in a windowless office in D.C. The endgame here is a total corporate capture of the healthcare delivery system. They want a world where safety net is a dirty word. They want a world where every single transaction, every single discount, and every single pill is mediated by a private third-party platform that can gatekeep the funds. Imagine a world where a hospital in Appalachia has to wait for a clearance from a software platform owned by the very people they're trying to buy the medicine from just to see if they can afford to keep their ER doors open that night. That is the warning. If this administration's nightmare is a court that demands evidence, then our nightmare is a government that agrees it doesn't need any. If they win the next round, the precedent is set. The government can ignore 1,100 public comments. They can ignore the reliance interests of the entire medical community. They can ignore the fact that they are literally violating the law as written in the 340B statute. And once that door is kicked open, it doesn't stop at drug rebates. It moves to Medicare, it moves to Social Security, it moves to every single public benefit that currently stands between a person and total financial ruin. They are trying to turn the public good into a subscription service managed by their donors. And they are doing it with the hope that we're too tired, too cynical, or too distracted by the theatrics to notice the forensic details of the theft. The stakes are simple. Are we a country that operates on the rule of law, where the government has to prove its case before it upends the lives of millions? Or are we moving toward a unitary executive, where the president's vibes are more important than the Administrative Procedure Act? The court just gave us a breather. They gave us a moment of clarity. They said you can't just do this because you want to. But the warning is loud and clear. They are going to keep trying. They are going to wait for the next crisis, the next emergency, or the next friendly judge to try and re-implement this. We have to stop treating these technical policy failures like they're boring. They aren't boring. They are blood. They are the difference between a clinic staying open or a town losing its only doctor. The end game isn't a better rebate system. It's a system where the government has zero power to protect you from the predatory instincts of a for-profit healthcare industry. The court froze the assets. They stopped the rollout, but they didn't kill the ambition. And if we don't demand a government that respects the work, that respects the data, the process, and the people, then this nightmare for Trump is only a temporary setback, and our nightmare is just getting started. We need to be as clinical as the First Circuit. We need to be as relentless as the AHA's legal team, because the people pushing this program, they aren't going away. They're just going back to the drawing board to see if they can make the next record a little less anemic while keeping the outcome just as deadly. So here we are. The court has spoken, the program is on ice, and the administration is fuming. But if you're waiting for a "The End" title card to crawl across the screen, I need you to snap out of it. This isn't the resolution of the story. It's a checkpoint in a war of attrition. The resolution isn't going to come from a judge's gavel in Boston, and it's certainly not going to come from a press release out of HHS. The resolution only happens when we decide that boring administrative law is actually the front line of our democracy. We've spent so much time screaming about the theater, the rallies, the tweets, the personalities, that we almost missed the fact that they were trying to rewrite the DNA of the American hospital system in the dark.
This First Circuit ruling is a victory, yes. It's a massive headline-grade defeat for an administration that thought it was untouchable. But a victory in court is just a stay of execution. The call to action here isn't just to celebrate a legal win, it's to develop a forensic memory. We need to stop letting them exhaust us. Their greatest weapon isn't their lawyers or their anemic records, it's our cynicism. They are counting on the fact that most people will hear 340B Drug Rebate Pilot and their eyes will glaze over. They are betting that you won't care about compliance costs or liquidity crises until it's your local hospital that's closing its doors. But by then, and by then, the no way back signal is already been sent. So here is what clarity looks like. We have to hold the line on the Administrative Act. It sounds dry, it sounds like something only a law professor would love, but it is the only thing standing between us and a government that can simply decree your rights away. We have to demand that every single pilot program, every executive order, and every regulatory tweak is backed by the kind of evidence that can survive a skeptical judge. If they want to change how our healthcare works, they have to show their work. No more vibes, no more move fast and break things. If they can't produce a record that isn't threadbare, then they shouldn't be allowed to touch the dials of the system. But there's a deeper call here. We need to start looking at who is funding the push for these rebate models. We need to look at the beacons of the world, the private third-party vendors who stand to make a killing by sitting in the middle of our healthcare transactions. We need to name the lobbyists and the policy advisors who are whispering these ideas into the ears of the powerful, because this nightmare for the administration only stays a nightmare if we keep the lights on. The end game is to make it politically and legally expensive for them to be this lazy. We need to support the organizations like the American Hospital Association when they actually fight back, not because we love every lobby, but because in this specific fight, they are the ones holding the shield for the rural clinics and the city safety nets. This isn't just about Trump. This is about the office of the president, regardless of who sits in it, learning that they are not a king. They are a servant of the statutes passed by Congress and the procedures established by law. The First Circuit just reminded them of that. Our job is to make sure they never forget it. So don't just like this victory. Understand the precedent. Understand that the reason they lost was because they were arrogant enough to think they didn't need to justify their actions to you, the courts, or the people whose lives were on the line.
Keep your eyes on the dockets. Keep your eyes on the boring news, because the next time they try this, and they will, they'll try to make it even more technical, even more obscure, and even harder to track. But we've seen the playbook now. We know the strategy. And as long as we have the real speak to break down their anemic excuses, they don't get to win in the dark. It's over for today. The assets are frozen, the program is dead in the water. But the fight for the soul of the administrative state, that's just getting started. And I don't know about you, but I'm not going anywhere. We're going to keep deconstructing the receipts until the receipts actually match the reality of a country that cares about its people. Stay sharp, stay skeptical, and for the love of everything, stay informed, because clarity is the only thing they can't survive.